Well, good evening, everyone. I am Attorney Neonu Jewell. I am the founder of Neon Edge Advisory, and I call myself the life and legacy lawyer because that's exactly what I help people protect. And today's session is completely educational, no pressure, no sales pitch. My only goal is to make sure you leave here knowing more than when you walked in. We have a lot of great content today, so let's get started. So, the first thing I want to do is go ahead and drop something in the chat here because today's session, as we will talk about it a little bit more in a moment, really is focused on education. You may find yourself having personal specific questions that you want to address that really you don't want to talk about publicly. And so the best way to do that is to book a one-on-one session with me where we can have a personalized life and legacy session. And this is a $550 value, but for all registrants and attendees for today, that will be complimentary. So let's get started. Before we dive in, a quick note. Everything I share today, like I said, is for educational purposes only. It's not legal advice and it does not create an attorney-client relationship. For advice specific to your situation, you'll want to work with a licensed Maryland or DC attorney or one in your state of residence. I'd love for that to be me. I'm passionate about legacy planning and economic empowerment, and I have spent thousands of hours honing my legal expertise. But today is about giving you the knowledge to make a great decision. Now, let's start with a question for you. Type yes in the chat if you personally know someone, a family member, a friend, a coworker who went through a difficult, expensive, or stressful probate process after a loved one passed away. Just type yes in the chat if that's your experience. Yes, yes, unfortunately, Bree says. Anyone else experience that? If you have not, good for you. I do probate, and I can honestly say there aren't too many happy stories talking about the probate process. People often wait over a year for the estate to close to receive their inheritance. Families pay tens of thousands in probate related fees sometimes. Siblings who hadn't argued in decades find themselves in conflict over their parents' wishes. My promise to you today, by the end of this session, you'll understand exactly why that happens and exactly what to do so it never happens to your family. Now, as we go along today, I am going to uh, share some of the most frequently asked questions or comments that I give and give the responses because you may be thinking the same thing, but for whatever reason, don't want to raise your hand. And, we limit the number of people that join this session because we want it to be interactive. So if you have questions, I know it's kind of weird. Jump in, come off mute, and just say, hey, can I ask a quick question before you move on? Because I really do not want you to forget your question. It may be that we just haven't gotten there yet. And if so, I'll let you know. But like I said, I don't want you to forget your questions. But one of the questions that I get at this point when I talk about family disputes is people say, well, my family isn't like that. We get along. And that's wonderful. And I hope it stays that way. But probate creates friction that didn't exist before. Even loving families face delays, costs, and decisions that no one was prepared for. And a good plan can protect those relationships, not just assets. So let me show you what we're covering today. Here's how our time today is structured. We'll move through 6 sections. We'll start with you, your goals and concerns. Then I'll show you what happens without a plan and what's possible with one. From there, we'll go deep on wills versus trust. Take your questions and finish with next steps. We'll have time for Q&A throughout, like I said, and at the end. But if you have something that's pertinent on a slide, feel free to jump in. If you type it in the chat, I may or may not see it, but I'll try and glance at the chat periodically as we go. So first, let's make sure you're in the right Zoom. This session is for three kinds of people. First, you know you need a plan, but you're not sure where to start or what you actually need. You've thought about it, maybe you've researched it a little, but you haven't taken action yet. Second, you're curious about what this costs. How long does it take? You want to understand the process before you commit to anything. Third, you've seen those $99 online trust kits and wondered, is that good enough? Why would I pay an attorney when I can just do it myself? If any of those describe you, you're in exactly the right place. We're going to answer all three questions today. Let's talk about what estate planning actually does for you because most people have the wrong idea. Let me clear up a misconception right away. Estate planning is not just about what happens when you die. It starts protecting you while you're still alive. Incapacity protection, if you have a stroke, an accident, or a serious illness, who makes the decisions about your care? Who manages your finances? Without documents in place, a court decides. They'll sign a guardian, a conservator, and there have been lots of cases on the news. Wendy Williams is one of the most famous about having a third party that you didn't choose coming in and making decisions about you and ending up in a situation that you did not want for yourself. With a plan, you decide in advance. Estate planning legally provides for your family. Your plan ensures that your children, whether minor or adult, are financially protected and that your wishes for them are honored. Asset protection. A properly structured plan helps you avoid probate, shields your assets from future creditors, a beneficiary's divorce or lawsuit, and can prepare you for the potential cost of long-term care. Legacy. This is one people often forget. Your plan is how you pass on not just your money, but also your values, your intentions, and instructions about what matters most to you. And yes, it reduces family conflict too. Now, here's a question that always gets interesting reactions. Type in the chat if you do not have an estate plan. If you do not have an estate plan currently, type 1 in the chat. One brave soul is willing to admit it. You're not alone. Okay. We've got a couple of ones here. I assume that's why a lot of you are here. Well, as you can see, the truth is that you actually do have an estate plan. You might not like it, but you do have one. Maryland and DC have written a default plan for every resident. It's called intestacy law. If you die without a will or trust, the state's plan goes into effect automatically. That plan decides who gets your assets, who raises your children, who manages your affairs. It doesn't know your family. It doesn't know your wishes. It just applies a formula. So when I say estate planning, what I really mean is opting out of the state's default plan and replacing it with your plan. Here's a question I get. What does the state's default plan actually say? Well, it depends on your situation. Whether you're married, have children, whether your parents are still living. In many cases, assets go to relatives in an order you might not choose. We can discuss your specific situation in a life and legacy planning session. So let's talk about one of the most important things your plan does while you're still alive. This slide is the one people are least prepared for. Nobody thinks about incapacity, but statistically, you are more likely to become temporarily or permanently incapacitated than you are to die young. If you become incapacitated without the right documents, a court appoints a guardian and a conservator to manage your health and your finances. This process is slow, expensive, and public. The three documents that protect you are the financial power of attorney, where you name someone you trust to manage your bank accounts, pay your bills, handle your investments, and make legal decisions on your behalf. The Advanced Healthcare Directive. This covers several things in Maryland, and DC has a similar form. Who makes medical decisions for you, your living will, which records your wishes about end of life care, life support. Do you want to get nutrition and hydration? Do you want pain meds if you're going to be uncomfortable? Organ donation, and as well as a HIPAA authorization. So the HIPAA authorization is not about who can make healthcare decisions on your behalf. This is who can receive healthcare information. Without this, even your closest family members cannot access your medical records or talk to your doctors. Now, this is one where I really, really think people are taking a chance. People are used to seeing in TV, and it might even be your lived experience that something happened to a loved one. They went to the hospital. You said that you were the parent, the spouse, and the doctor gave you information. Those doctors were giving you a courtesy. They do not have to do that. And actually, by law, they're not supposed to. Without your name being listed on a properly, legally ratified HIPAA authorization, if your child is over 18 years old, or even if it is your spouse or your sister or your parent, they do not have to give you any information. So, this is a critical document for all adults. This document gives them that permission. So here I get the question. My spouse can just handle things for me if something happens to me, right? Well, as I just described, not necessarily. Without a financial power of attorney, your spouse may not have legal authority over accounts held in your name alone. Maryland and DC are separate property states. And so if you have accounts in just your name, a spouse simply saying that they're a spouse does not give them legal right to have access. And actually, the institutions could find them in in hot water and held liable for giving them access to those accounts. So your business interests, your investment accounts, and if something happens to both of you simultaneously, then these documents become even more critical. So let's get into the big question now. Wills versus trust. This is the heart of today's discussion. Two paths, very different outcome. Let's walk you through both so you can understand exactly what you be choosing and why it matters, particularly in Maryland and DC. And something that's important to note is that estate planning is state specific. And so not all states have the same rules. Estate planning can even be more local and down to the county level. So it's important to know what the rules and laws are in your state. So let's start with the bad news about wills. Where there's a will, there is probate. I want to say something that surprises most people. A will does not keep your family out of court. A will does not keep your family out of court. In fact, a will makes it more likely that your family will go to court. A will only takes effect after it goes through the probate process every single time, no exceptions. Now, you may be thinking, I have a loved one who passed away and we didn't go through the probate process. So there are people who don't go through the probate process, people who are unaware of the probate process, And then later down the line, let's say there's a home, they go to sell it and they wonder why they can't sell it because they never went through the probate process. And although they thought they inherited that property, they did not. And now, years later, you still have to go through the probate process before that property can be transferred. Every family that may have an interest is notified and can petition the court to take exception to any will's provisions. And even if everyone agrees, probate in Maryland and DC have four major downsides. Let's go through each one. First, probate is expensive. Probate costs run 4 to 7% of the total value in Maryland and 3 to 9% of the total value in DC. On a modest estate, that's still thousands of dollars. On a larger estate, it can be tens of thousands. Probate is time consuming. The average Maryland probate takes 9 to 12 months, and it's common for it to stretch out over 2 years. And during that time, assets are frozen. Your family cannot access or distribute assets until the probate process completely closes. So instead of mourning the loss of your loved one and beginning to heal, you're scratching your head about a complex legal process and family disputes. It's a public record. Your will becomes public, and it's a document that will be filed in the county that you live in. In every county in Maryland, when someone passes away and they have a will, that will has to be filed in the county in which that person resides. And as soon as it is filed, it becomes a public record. And in this day and age of scammers, unfortunately, there are people who make a living on pulling these records to see who might have inherited recently that they can find on the internet, whose identity they might try to steal. Anyone can look up what you own, who got it, see the names of your minor children, how much money you died with, who your creditors were. All of it becomes public. Another downside, outright inheritance. All heirs will inherit a lump sum when probate closes, including children over 18. An 18-year-old with a large inheritance and no strings attached? Think about that. Let me show you what this actually looks like in dollars. Let me walk you through a real example. Meet LaTanya. She's a single mom. She has a home, some savings, life insurance, and retirement accounts. She has a will. When we add it all up, LaTanya's estate is worth over just $2 million. That sounds like a lot, and it is. But watch what happens when her will goes through probate. At a conservative 4%, I say conservative because recall in Maryland, probate is anywhere from 4 to 7%, and in DC, 3 to 9%. The higher the estate value, the higher the percentage. So in reality, LaTanya's $2 million estate would not be 4%, but we're going to be conservative here. And that cost would be $80,800. That money goes to court fees, attorneys, and administrative costs. It doesn't go to her children. And remember, this is at the low end. At 7%, we're talking about over $180,000 that goes to the state as opposed to the beneficiaries. There's also something important to notice here. The life insurance and retirement accounts are listed as payable to minor. That's a serious problem. A minor cannot legally receive that money directly. It would go into a court supervised account until age 18 and then would be released as a lump sum with no restriction. That is not what LaTanya wanted. Question: what if my estate isn't that large? The same principles apply at any size. And here's the thing. Most people underestimate the size of their estate. I see it every day in my practice. People are surprised when we add up and actually come up to the value of their estate. If you want to know the value of your estate, this is what we can walk through in a personal session. So book your life and legacy planning session with me today. Do it now while we're on the phone, while you're thinking about it. There are additional categories besides just your house and your retirement accounts. You have cars and businesses that aren't included here on the sheet. And like I said, at a life and legacy planning session, we can go through that together. So, what's the alternative? Let's talk about how assets actually pass and why a revocable living trust solves this. Before I introduce the revocable living trust, I want to make sure you understand something foundational. There are three ways to own property at the time of your death, and each one has completely different outcome. First, individually, a bank account in your name alone, a brokerage account, real estate titled only to you. When you die, these assets go through probate. The court controls the process, the timeline, and the costs. Second, jointly. Your home, for example, held jointly with your spouse. When one spouse dies, it passes automatically to the survivor. Simple, but when the last surviving spouse dies, that jointly held property goes through probate unless something else is done. Third, by contract. These are your retirement accounts, your life insurance policies. These pass directly to the named beneficiary. No probate, so no problem. But here's the catch. That only works if the beneficiary is alive and over 18. If you named a minor as a beneficiary, the money cannot go directly to them, as we just discussed. A court has to step in. And so here is why this matters. Many people think that because they have a beneficiary designation on their 401k, their IRA, their TSP, life insurance, that they're protected. And they are, unless something goes wrong with those designations. You get divorced and you forget to update the designation. Someone predeceases you, or someone is a minor. Your revocable living trust can serve as the beneficiary instead, giving you full control over how and when those funds are distributed. When we meet one-on-one, we go through all of this and determine what makes the most sense given your situation and goals. So some may say, so I just need to update my beneficiary designations. Then I'm good. No probate. Well, yes, updating beneficiary designations is necessary, but it's not sufficient on its own. If you name a minor or someone with a disability, or if your primary beneficiary predeceases you, as I said, you can still end up in court. A properly funded revocable living trust coordinates all of this on your behalf. And that brings us to the solution. Here's the simplest way to understand a revocable living trust. It does everything people assume a will does, but it actually works. Think of a revocable living trust as a treasure chest. And all of your assets, house, car, household goods, bank accounts, all your assets are your treasures. Right now, all your treasures are outside of the treasure chest. They're in your name, whether individually, jointly, or by contract. The trust is the treasure chest where your treasures are protected from the probate pirates. When you create the trust, you move your assets into it by retitling to the trust names. The trust name is a name that you give it. You can name your trust whatever you want, but I remind my clients, this is a legal document. So pick a name that you want to share more broadly. And when you retitle your assets into your revocable living trust, when you move your treasures into your revocable living trust treasure chest, that's called funding your trust. Assets inside the chest bypass probate. completely when you die. So by getting your treasures in your treasure chest, you avoid probate and all those downsides. Your successor trustee distributes your assets according to your instructions, privately, quickly, without court or county involvement. Assets that stay outside the chest still go through probate. That's why funding is critical and why do it yourself revocable living trusts often fail. The documents exist. So step one of the process has been met, though it may not comply with Maryland or DC law or have the proper notary and witness signatures, but the assets were never moved into the chest. Step two. Thank you, Alana. And here's what makes a revocable living trust revocable. You can change it, update it, or even revoke it entirely while you're alive. You stay in complete control. Can I just use LegalZoom or a free online template? You can create a document online, but a trust that isn't properly funded is worse than no trust at all. And again, estate planning law is state specific, sometimes county specific. If you're pulling anything offline, you would want to be sure it complies with the latest Maryland DC law. And these rules do update, requirements of the counties do change, and you can't be sure if you are not having someone who is full-time estate planning attorney invested in this. So just keep that in mind. It can create a false sense of security. Generic tools usually don't know Maryland and DC law. They don't help you retitle your assets, and they may not address incapacity. So the document alone is not enough. That's the big takeaway. The document alone is not enough. Now, let's put a will and a trust side by side so you can see exactly what you're choosing between. Let's make this concrete. 7 categories, 2 options, and as you can see, the trust wins in every single one. Probate, wills require it. Trust, avoid it entirely. Privacy, wills become public court records. Trusts are completely private. Incapacity, wills offer zero protection during lifetime. A trust with a successor trustee means someone can step in immediately if you're incapacitated. No court petition required. Minor children, wills leave assets outright at 18. A trust lets you set conditions if you want. Money can be released for health, education, maintenance support, or you can say, no, you don't get it all at 18. Maybe you get some at 20, some at 30, some at 40, or you can just say you get everything when you turn 27 and graduate college. There's conditions that you can set, you decide them, we put them in your trust. Cost. Wills will trigger that 4 to 9% in probate costs. A trust has a minimal ongoing cost and no court fees at death. Speed. Probate takes 9 to 24 months or longer. A trust can distribute assets in weeks. Family conflict. Wills can be contested in court. A trust is significantly harder to challenge and creates clear private instructions that reduce ambiguity. Another reason to have an attorney do it for you to ensure it has all of the proper legal language should it ever be challenged, that you have language that will stand the test of time and stand the law in the state and county that you live in. So let me show you how the trust actually works, who's involved, and what their roles are. Every trust has 3 roles: the grantor, the trustee, and the beneficiary. Here's the elegant part of a revocable living trust. During your lifetime, you hold all 3 roles simultaneously. As the grantor, you created the trust and contributed your assets to it. As the trustee, you manage those assets exactly as you do today. No change in how you bank, invest, or use your property. As the beneficiary, you benefit from those assets while you're alive. You are in total control. Nothing changes in your day to day life. The only real difference is what happens when you die or become incapacitated. Your successor trustee steps in, the person you chose, following the instructions you wrote without any court involvement. Well, who should I name as a successor trustee? Yes, that is one of the most important decisions you'll make. And it's something we'll work through together in your planning session. Generally, it's someone you trust deeply who is organized and capable of handling financial and legal matters. So, I want to discuss one more trust concept that matters a great deal if you have children. Think about a tube of toothpaste. That's a children's subtrust. While we're talking about this in the context of children, it's actually not limited to children. It's anyone that's a beneficiary, but this shows up most often with people with children. So we're just going to call it the children's subtrust. Your child or any beneficiary can squeeze money out of a revocable living trust when they need it for real purposes. Like I said, education, healthcare, buying a new home, starting a new business. You set the terms, they have access. But what's still in the tube is protected. If your child gets divorced, a creditor can't reach that money. If they get sued, that money is shielded. What's in the tube stays in the tube until it's legitimately needed. And here's what makes it still flexible. You can name a trustee to manage it. It can be the successor trustee of your trust, or for a financially responsible adult child, you can let them serve as their own trustee. They can be the trustee of their own subtrust. They have access and control, but the remaining balance is still protected. This is the sophisticated asset protection planning we can do with a revocable living trust. A will doesn't do any of this. A will drops the entire inheritance in your child's lap as long as they're over 18, with no conditions, no protection, and no guidance. So let me put the contrast in the starkest possible terms. This is the simplest summary I can give you. Wills lead to probate. Probate leads to stress and cost. Trusts lead to the opposite of all of that. On the will side, your family goes to court or through a long probate process. Your assets become public. There's more opportunity for conflict. Your children get a lump sum. If they're 18, if they're under 18, someone has to be appointed by the court to manage the money. And tens of thousands of dollars leave your estate unnecessarily. But on the trust side, no probate ever, as long as you fund your trust. It's a two-step process: creating the document, funding the trust. There's complete privacy, clear instructions that are harder to dispute, controlled distributions are available to your children, and more money ultimately going to the people you love. So the question isn't really will or trust, not in Maryland and DC. The question is, which outcome do you want for your family? Let me share what some of our clients have said about going through this process. I'll read this one in the middle. I'm really glad I engaged Neon Edge Advisory for my estate needs. From our first meeting, Neonu Jewell was warm and engaging and put me at ease. She took the time to review options, ask questions to discover what was important to me and what my goals were, and advise the next steps based on my needs. I highly recommend her services. Thank you, Michelle, Metallic Rose, and Mark White. As I said in the beginning, I'm passionate about this. I've spent thousands of hours honing my expertise, my legal expertise, my estate planning expertise, and really, I care about this for you as much as you care about this for you. You may not think that's possible, but it really is. And so it is my goal always to deliver five-star service. And so I am grateful and feel good when my clients do, in fact, give me 5 stars. And at this point, all of my ratings are 5 stars. So, what does the next step actually look like? Like I said, the life and legacy planning session, it's private. It's one-on-one with me. This is where everything becomes personal. In your session, we do 4 things. First, we review your specific assets, what you own, how it's titled, and how it would actually pass at your death under current law. Second, we calculate your actual probate exposure, not Latanya's numbers, your numbers. You'll see exactly what probate would cost your family if nothing changes. Third, we design your personalized plan, will versus trust. And if a trust, what type of trust? What do you want? Do you want a children's trust subplan? Do you want a pets trust? Do you have a child with special needs? We'll go over which options make sense for your family structure, your assets, and your goals. And fourth, you leave with a clear action plan, not a vague to-do list, but a specific roadmap for what happens next. There's no pressure in this session. If we're a good fit to work together, we'll talk about next steps. If not, you'll still leave more informed than anyone else in your circle about how to protect your family. So I will post once again the link here to schedule your life and legacy planning session, which is your next step. So I just dropped the booking link in the chat. If you know this is for you, go ahead and grab a time while we're finishing up. We've got limited slots, so get them and get a time that works best for you. Question I get, how long is the LLPS and what does it cost? The session is complimentary to all of the attendees and registrants of this particular webinar. So there's no charge to meet with me. It typically runs about 60 minutes. And at the end of the session, if we decide to move forward, we'll discuss your estate plan options and investment at that time, because it'll be based on your family and your goals. Can I bring my spouse? Absolutely. And actually, I require it. And so book a time that works for both you and your spouse if you're married or have a life partner. Estate planning's decisions affect both of you, and it's far more effective when both spouses hear the same information at the same time. So, before we wrap up, I want to address the most common reason people put this off. 60% of Americans have no estate plan at all. Not because they don't care about their family, but because they keep waiting for the right time. It's on the to-do list. Yes, I know I'm an adult and this is something I should do. Yes, I'm going to do it. I mean to do it tomorrow, tomorrow, tomorrow. Here's the hard truth. Every day without a plan, your family is one accident away from a courthouse. The average Maryland probate takes 18 months. $80,000 or more can evaporate in fees on a typical estate, and 100% of that is avoidable with the right plan in place. Knowledge isn't enough. As Jim Quick says, knowledge only becomes powerful when you act on it. You came here today because you care about your family. Don't let today be another thing you learned and then waited on. And when I say you care about your family may just be you. You may be a single person and you are your family and you care about yourself from an incapacity standpoint, an economic empowerment standpoint, and a legacy standpoint. So take one action before this week is over. Here's your 3-step action plan to do exactly that. 3 steps. That's all it takes to go from today's seminar to having a plan to protect your family. Step one, book your life and legacy planning session. The link is on the screen and I'll put it in the chat. It only takes about 60 seconds to grab a time. And anyone that books a life and legacy planning session and meets with me by April 10th and secures a plan will get either $250 or $300 off of their plan, depending on what plan they select. So there's a lot of incentive to go ahead and book your slot now and then to meet with me before April 10th. And if you select a plan, you will get a discount just because you attended this seminar. So after you set your meeting, you're going to get a Life and Legacy Launcher questionnaire. It'll come to you automatically. It takes about 15 minutes and helps me have you come prepared to talk specifically about your situation. So complete your questionnaire before we meet and then show up to your session. That's it. We do the rest together. Protecting what matters most starts with one conversation. So book your complimentary, personalized life and legacy planning session now. With that, I bring our time to a close. Once again, I'm Neonu Jewell. I am the Life and Legacy Lawyer. This is how you reach me. We're based in Columbia, Maryland, and we serve clients throughout Maryland and the District of Columbia. All of our sessions are available via Zoom, so geography is never a barrier. You don't have to get dressed up. You don't have to leave your house to meet me. So if you haven't booked your session yet, there's still time, and the link is in the chat. And if you found today valuable, I have one small ask. Leave us a Google review. If this has been a 5-star education experience, we would appreciate a 5-star rating. It means the world to us.